Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and the Gramm-Leach-Bliley Act safeguard rule updates for 2022. So the Gramm-Leach-Bliley Act is an act that was put into place many years ago related to how financial institutions created transparency with users and also with consumers basically, and also the government. So an example of that may be, let's say your financial institution, for example, has to send you a privacy notice every year. Okay, so in 2022, in December of 2022, a new rule for safeguarding data will go into effect. I'm surprised that a lot more people aren't talking about this. It's actually a big deal. This is a very major update to Gramm-Leach-Bliley. There are actually quite a few significant changes that are made here, but I'll just talk about three. So the three big changes I think to Gramm-Leach-Bliley that companies need to really be thinking about are the expansion of the definition of financial institution. So when people think about financial institutions, they think of banks and lenders and people like that, but this rule really expands that definition. So that includes maybe now tax preparation companies that are considered like finders. Like, for example, let's say you have an organization and you're kind of a marketplace where you put buyers and sellers together. You may be considered a financial institution. So a lot of the rules that maybe sort of banks and traditional financial institutions have had to deal with, these companies now that are now considered financial institutions really need to look at Gramm-Leach-Bliley because it probably applies to them now. This safeguard rule also has a rule around qualified individuals. So being able to have someone within your organization who understands things like cybersecurity and data protection. So either inside or outside, it doesn't matter. And actually they don't list what they consider a qualification there for what, this person needs to maybe have certain credentials. But I think this is what I call like the one throat to choke part of the rule, which is, let's find someone, instead of saying like, for example, cybersecurity or privacy is everyone's responsibility. Gramm-Leach-Bliley says actually, well, regardless of it's everyone's responsibility, someone needs to be accountable, and they want you to sort of name who that person is within your organization or outside of your organization. Also, they're wanting organizations to be able to have written policies, procedures, and disclosures, and also make more of a risk-based approach to how they handle data privacy. So this is a big deal. Not all companies, unfortunately, have written procedures, or they don't have kind of risk-based approaches where they're looking at their maturity over time. So, this is, for, let's say, bigger institutions like banks that have been accustomed to Gramm-Leach-Bliley, I don't think this is going to be hard for them to change, but definitely companies that had not previously thought Gramm-Leach-Bliley applied to them, this would be a big change. And also maybe smaller companies that didn't think that these things apply to them, this may be a heavy lift for them. So, December 2020 is not that long away. 2022, December 2022 is not that far away. I think that companies need to really look closely at this, because some of the things that are here are, in my view, pretty common sense things that should be applied, and probably, depending on the success of this, I can see this floating into different sectors of businesses within the U.S. So it remains to be seen what happens here. I'll probably be talking a little bit more about this because the changes, as I said, are significant. So I think it's something that people need to look at more closely and get more familiar with it in regulation. That's it. Thank you.